Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Well, I'm about half put together today. I spent the weekend power washing my house and sidewalks around my house, and it was about 90 degrees with about 3,000% humidity here in Alabama, and it was sort of a miserable day to be out there in the sun doing that. But the problem with getting a chore like that done is you just have to go through it and get it done. There's no way around not doing it. So at any rate, that's why I look probably a little sleepier than I would be otherwise. There are a couple of things I want to talk about in the news that I think are worthy of mention. The first has to do with the trial of former President Trump in New York City. And the judge, as you may all know, wrote a letter to the defense counsel and to the prosecutors saying that somebody posted on the Unified Court System Facebook page basically a message prior to the verdict coming out that said his cousin was on the jury and they were going to convict Trump. As a result, he sent that out to the attorneys to make them aware of that. Now, you may be wondering what the impact of that might wind up being. And so I'm not as familiar with New York law as I am most other states, but I can tell you that there needs to be an investigation. And normally, counsel would cooperate in that. I don't think that necessarily is going to happen here. But what would normally happen is, if I were representing the former president here, what I'd do is I would send out subpoenas. I would hire an investigator, find out who the person who made the post was. I would subpoena that person to court, and I would also gather as much background information on him as possible. Now, there are a couple of possibilities here, right? The first is that he had a cousin on the jury, and the cousin told him, "Oh yeah, we've been talking about this all week. We're gonna convict him." In which case, they would have been ignoring the court's instructions, and because the jury didn't adhere to the instructions, well, you might have a problem then. The failure to follow the instructions, or I should say the rampant disregard of the instructions, might be grounds for a mistrial. And in a high-profile case like this, you would probably want to give the defendant every benefit of the doubt, and I suspect that could happen. But there is a far more likely scenario, and that is that this guy is just a jokester, somebody who likes to stir the pot, who likes to appear to know things that other people don't know, who wants to be the first online to say something about something. And there are an awful lot of people out there with a lot fewer brain cells than they need to get along in life who wind up doing things like that. Now, if you think about the time, effort, and money that went into producing that trial on both sides, and you think about having to redo it again because somebody did something like this, well, there ought to be some consequences for that, but there probably would not be. There's absolutely no law that says you can't lie on Facebook, because if there was, probably 10 or 20 million people would be in jail, because a lot of people lie on Facebook. The issue, though, is what would happen to this guy if they found out he did just do this? Nothing. He's probably protected by the First Amendment. And as he should be. The First Amendment is there to protect all of us, and in order for it to protect all of us, it has to protect the least of us. So those are really the two options. Now, if indeed he comes in and says, "Yeah, I had a cousin on the jury," then they're going to have to bring in the jury. They're going to have to subpoena the jury, bring them back in, and the judge is going to have to question them very much the way it happened in the Murdaugh case.
Usually matters involving possible improper contact with or conduct of a juror arise during or shortly after the trial. The judge then puts the affected juror or jurors under oath, conducts an examination, and rules on the request for a new trial or a mistrial.
You may recall back in the Murdaugh case, they had to bring in a separate former Supreme Court judge to conduct an investigation as to whether or not there was some kind of tampering by the idiot court clerk who decided to vent her spleen on the jury about Alec Murdaugh. That, again, people do really dumb things, and I think a lot of it is chasing fame and chasing notoriety. My experience with fame and notoriety are that they are addictive drugs, and that people who chase them tend to be a bit narcissistic, and so I like to stay away from those people. But those are really the things that could happen there. Is it likely that there'll be a mistrial? Probably not. I strongly suspect that the guy was just being a jerk. But we'll find out having notified the parties, it's up to the parties to do the investigation. They can solicit the court's help, but it's up to the parties to do the investigation because they're the people who have an interest in this. And the second thing that is coming up is the Hunter Biden trial. He is on the hook for having falsified a Form 4473, which is what you have to fill out when you go to purchase things that go bang. For some reason, my videos have been categorized as unmonetizable whenever I have mentioned the colloquial term for things that go bang. And so for that reason, I'm not using that term. But I have the smartest group of people out there in YouTube land, so I know you understand what I mean. The issue with the falsification is he signed the form saying that he was not addicted to drugs. And the 4473, in the event you've never filled one out or had the opportunity to see it in action, it is a form that is required to be filled out under penalty of perjury, which means if you lie on that form, you commit the crime of perjury. And in that case, it's a federal crime. And that is what Mr. Biden is charged with in at least one count. And the problem with his answer is that he had just gone through rehab. Now, as anybody who has any experience at all with alcoholics or other substance abusers knows, rehab is not the silver bullet. It doesn't fix the problem. The only way to fix the problem is to fix the human heart that it is addicted, and you have to do something pretty substantial to do that. You have to change your life. I know because my mother was an alcoholic, and it took her a really long time to make her way in the world and make it correctly. She, up until the time I was 16 years old, was drinking. And a lot of times she ignored her duties as a wife and mother, and it caused a lot of family grief. But she was able to get through that, and she was able to beat that addiction. But she would never say that she beat the addiction. She would say, I'm an alcoholic every day, but I'm in remission. And I think that is an important characteristic. Once you become addicted to a substance like that, you're never really cured. My former mother-in-law was a smoker for many years. And when her husband quit smoking, she quit smoking too. But she often said that she would gladly light a cigarette a football field long and smoke it, if at all possible, because she really enjoyed that addiction. And a lot of people do enjoy their addictions. But that's what Hunter is on trial for. The thing that is interesting about the trial is that he denies that he was addicted at the time, and he denies that he knowingly lied on the form. Well, you have to lie knowingly. And what that essentially means is he had to know that he was addicted, and he had to know that he wasn't telling the truth when he checked that box. Now, the defense has done all kinds of things that I believe are probably pretty counterproductive. They have asserted that the clerk at the store should have read the form to him so that he could understand it, as if perhaps this man who is described by President Biden as the smartest man he knows was not capable of reading the form, was not capable of understanding the form. And I think that does such a disservice both to Hunter and to the jury. Because if I'm sitting on that jury, I'm thinking, are you serious? You went through high school, you went through college, you went through law school, you practiced law for 30 years, and now you're saying you don't understand what this particular question means? Are you serious? And so there have been a number of whispers that because the trial is being held in Delaware, which is Biden's home state, and because the family has appeared regularly at the trial in support of Hunter, that as a result of that, there is some belief that there is an attempt to get jury nullification. Now, we've talked about jury nullification on the channel before. One of the first instances of jury nullification was in the 1700s when John Adams defended a British soldier who was charged with murder and was able, essentially, with pretty good evidence that he did kill this person, get him off essentially through a jury nullification verdict. And in a jury nullification verdict, what happens is the evidence is 100% strong. You've got a perfect case against the defendant, and the jury comes back and says, nah, not today. Sorry, nope, we're going to acquit. And of course, if he's acquitted, he's good. No more problems because of the double jeopardy clause. So it will be interesting to see, I think, what the jury does in this case. Over the weekend, they were trying to assess whether or not they were going to put Hunter Biden on the stand. I think that if they put him on the stand, he would be subjected to such a blistering cross-examination because he did the ABC interview. He did all kinds of interviews. He wrote a book. There are so many passages in that book that could be used to slap him upside the head about the addiction. And the idea that he didn't know he was addicted or didn't think he was addicted is just pure poppycock because he was essentially using drugs before he bought the item, and he was using drugs after he bought the item, and it was the same set of drugs, crack cocaine, which I understand is fairly addictive and can be pretty devastating in someone's life. The guy went through millions of dollars on dope, and that's really a shame. It's a loss of human dignity to be subjugated by a drug, to make that drug the most important thing in your life, more important than your children, more important than your family, more important than your friends, more important than your job, and more important than your life. But unfortunately, that's how some of these drugs act. Crack cocaine is like that. Crystal methamphetamine is like that. There are a number, I guess heroin to a certain extent is like that. Those drugs will ruin a person's life. And Hunter should have known that. He was a smart guy, but he, for whatever reason, he really messed up. And he's messed up big time. And we'll have to see what the jury does. Is it possible that there'd be a jury nullification verdict? Sure, it's possible. But again, President Biden has said he won't pardon Hunter if he's convicted. But I don't know how a father couldn't do that. He would have up until the last hour that he was in office to do that. Once, essentially he could do it pretty quickly if he wanted to, or he could wait until the end of his term and do it. Lots of different things. He would certainly have to wait until after the election to do it because that would have a pretty devastating impact on how people would view him, and it would look perhaps somewhat corrupt. I don't know. At any rate, that's what I have for you today. A little bit of jury drama on one hand and a little bit of jury nullification on the other. Maybe. We'll have to see. If you have the opportunity today, do something nice for somebody. Go out of your way. Do something kind. And then come on back down here and catch me at the beach next time, and we'll talk about something else maybe in the news. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.